Welcome to this primer on the Rules of Court 2021. This primer aims to provide court users and members of the bar with a basic understanding of the background and some of the key features in the Rules of Court 2021. The Rules of Court 2021 are the culmination of the work of the Civil Justice Commission and the Civil Justice Review Committee, which were tasked with studying reforms to the civil justice landscape in Singapore. Broadly, the mandate of both committees was to reform and modernize our civil justice system. The intent was to enhance the efficiency of resolving disputes while keeping legal costs at reasonable levels, and to ensure that our system would be capable of meeting the demands and challenges of the future. The CJC was established with the following terms of reference. First, to transform, not merely reform, the litigation process by modernizing it, enhancing efficiency and speed of adjudication, and maintaining costs at reasonable levels. Second, the key areas are to simplify rules, avoid outdated language without discarding established legal concepts, eliminate time-consuming or cost-wasting procedural steps, ensure fairness to all litigants, make good use of advancements in information technology, and allow greater judicial control of the entire litigation process. The CJRC was tasked to make recommendations to enhance judicial control over litigation and civil procedure. Both committees comprised members of the judiciary, representatives from the Attorney General's chambers, senior practitioners from the bar, and academics. The recommendations of the committees were published in separate reports before they were released for public consultation with the bar and other stakeholders in the industry. In June 2021, a joint consultation report was released by the Ministry of Law and the Rules of Court 2021 implementation team. The reforms are the product of wide-ranging and comprehensive deliberations, and they aim to enhance access to justice and efficiency in the civil justice system. Certain terms used in the existing Rules of Court 2014 edition will be modernized under the Rules of Court 2021. On the next two slides, see some of the terms which are commonly used in the process of civil proceedings have been updated. In this primer, the following key aspects in the Rules of Court 2021 will be covered. These are: first, the ideals of the Rules of Court 2021. Second, the general powers of the court. Next, an overview of the progress of an action, followed by case management. We will also touch on the single application pending trial. Finally, we will touch on the exchange of affidavits of evidence in chief, followed by the production of documents, expert evidence, and amicable resolution of cases. The Rules of Court 2021 are underpinned by ideals which are intended to guide the parties and the court in the conduct of civil proceedings. The rules seek to achieve the following ideals or aspirations. First, fair access to justice. Second, expeditious proceedings. Third, cost-effective work proportionate to the nature and importance of the action, the complexity of the claim, as well as the difficulty or novelty of the issues and questions it raises, and the amount or value of the claim. Fourth, efficient use of court resources. And fifth, fair and practical results suited to the needs of the parties. All parties have a duty to assist the court and to conduct their cases in a manner which will help to achieve these ideals. The ideals are not to be applied in a formulaic manner and are to be read conjunctively as dictated by the circumstances of each case. Under the Rules of Court 2021, the court also has specific powers. First, where there is no rule governing a matter, what the court does must be consistent with the ideals. In exercising any power, the court may impose any condition or give such directions that are appropriate. Second, where there is non-compliance with the rules, any other written law, the court's orders or directions, or any practice directions, the court may waive the non-compliance if the written law allows such waiver or dismiss, stay, or set aside any proceedings and give the appropriate judgment or order, even though the non-compliance could be compensated by costs if the non-compliance is inconsistent with any of the ideals in a material way. For further information on what is new under the Rules of Court 2021 and how to start a case, please refer to Digest 1, available on the Singapore Court's website. This slide sets out what a typical action commenced by way of an originating claim or an originating application looks like. A key aspect of the Rules of Court 2021 is the emphasis on case management, in particular on time and costs. Case conferences by the registrars and the judges will be the key plank to case management. Judges will be involved earlier in the case management process so that directions on the conduct of the case may be given by the judges at an earlier stage, with a view to achieving the ideals. Prior to the first registrar's case conference, or what is known as an RCC, parties will be asked to fill in a standard template pre-case conference questionnaire. This is to focus parties on the key issues and identify points of agreement. The RCC registrar will discuss the issues raised in the PCQ with the parties and give directions as necessary. Generally, it is anticipated that for a typical case, there will be about 2 to 3 case conferences before the judges, and about 4 to 6 case conferences before the registrars. The exact number of case conferences will depend on the specific circumstances of each case. For further information on how case management will be different, please refer to Digest 2, available on the Singapore Court's website. One of the key innovations of the Rules of Court 2021 is the single application pending trial. As far as possible, the court must order a single application pending trial, or SAPT, to be made by each of the parties. The SAPT should deal with all matters that are necessary for the case to proceed expeditiously. However, please note that a single application does not necessarily mean that parties are restricted to a single type of relief or to a single hearing. A single application also does not mean that all the parties have to file one application. Each party will be allowed to file one single application pending trial. The matters in a SAPT can be disposed of over several hearings, which may be heard by registrars or judges. Parties will be informed of the court's directions on whether a particular matter within the SAPT is to be heard by a judge or a registrar. No application may be taken out by any party at any time other than as directed at a case conference or with the court's approval, except for a specified list of applications set out in the new rules. For example, it may be appropriate for certain interlocutory applications, such as applications for summary judgment and striking out of the whole action or defense to be dealt with before the SAPT, in order to avoid wasted costs. Generally, the SAPT will be ordered to be filed after general production of documents has been completed. In cases where the court has made a direction for AEICs to be filed before the production of documents, the court will generally direct the SAPT to be filed after the exchange of AEICs. The court's approval to file further applications other than those already directed by the court must be sought by a letter setting out the essence of the intended application and the reasons why it is necessary at that stage of the proceedings. The request can be dealt with by letter summarily, or a case conference can be fixed to deal with the matter. Parties will not be able to take out any application starting 14 days before the commencement of the trial and ending when the court has determined the merits of the action, except in a special case and with the trial judge's approval. In the event of an appeal from a matter in the SAPT, the appeal will be heard only after the last matter in the SAPT has been heard, unless parties seek permission for an appeal to be heard first. For further information on the SAPT, please refer to Digest 3, available on the Singapore Court's website. Another key innovation under Rules of Court 2021 is that the court has the discretion to order AEICs to be filed and served before the production of documents. This will not be an exception under the rules. Generally, the AEICs to be filed before the production of documents will contain factual evidence only. The key consideration for the court in determining when the AEICs should be filed is the claim and defense put in by the parties and what the claimant requires to prove its case. The factual evidence will allow for the key issues in the suit to be crystallized and provide more clarity on whether expert evidence is required. The court may order the parties to file and serve AEICs either simultaneously or in any particular sequence. We highlight two key features relating to the production of documents. First, the parties' initial obligation to produce documents will also include all known adverse documents. Known adverse documents include documents which a party ought reasonably to know are adverse to the party's case. Second, the court shall not order production of private or internal correspondence except in a special case, or if such correspondence are known adverse documents. The term special case is adopted to allow for flexibility and good sense should a rare case emerge. For further information on AEICs and production of documents, please refer to Digest 4, available on the Singapore Court's website. We turn now to another aspect of the rules, that is, on expert evidence. Under the Rules of Court 2021, parties have to inform the court during the registrar's case conference if they intend to rely on expert evidence. No expert evidence may be used in court unless the court approves. The parties must consider whether expert evidence will contribute materially to the determination of any issue that relates to scientific, technical, or other specialized knowledge, and whether such issue can be resolved by an agreed statement of facts or by submissions based on mutually agreed materials. The court will not approve the use of expert evidence unless it will contribute materially to the determination of any issue in the case and the issue cannot be resolved. In addition, the court may disallow the use of or reject any expert evidence if it is of the opinion that the expert lacks the requisite specialized knowledge in the issues referred to him or her, or that he or she lacks impartiality. To assist the court and parties in distilling the issues, parties will be asked to fill up an expert witness template prior to the registrar's case conference where the issue of expert evidence may be discussed. This template is divided into 3 sections. The first section of the expert witness template relates to general information on the proposed expert or experts, their area of expertise and discipline, their qualifications showing that they have requisite specialized knowledge in the issues referred to them, any present and past relationship with any of the parties, counsel, and other witnesses, and whether the proposed expert or experts was involved in the matter prior to the trial and the capacity in which he was involved. The second section of the template focuses on the list of issues, facts, and documents in the claim. This include the specific instructions to be given to each proposed expert or experts on which he is to provide his opinion and conclusions, sets out the list of issues to be referred to the expert, a full and detailed description of the facts or assumed facts upon which each proposed expert or experts will consider in reaching its opinion, and states whether more than one expert would be relied on for an issue. Parties will be asked to provide justifications. Finally, the third section of the template sets out the anticipated timelines, such as how much time the proposed expert or experts will require to put together their opinion and how much time the proposed expert or experts will need if he testifies. Parties may wish to note that at the Registrar's case conference, they will be encouraged to come to a view on what the list of issues are and the common set of agreed or assumed facts. This may require 2 to 3 Registrar's case conferences on the issue of expert evidence before the parties will be able to reach an agreement. One of the innovative features of the rules is the court's power to order the parties to attempt to resolve the dispute by amicable resolution. In deciding whether to exercise its power, the court must have regard to the ideals and all other relevant circumstances, including whether any of the parties have refused to attempt to resolve the dispute by amicable resolution. The court may suggest solutions for the amicable resolution of the dispute to the parties at any time as the court thinks fit. The court may order the party who does not wish to attempt to resolve the dispute by amicable resolution to submit a sealed document setting out the parties' reasons for such refusal. The sealed document will only be opened by the court after the determination of the merits of the action or appeal, and its contents may be referred to on any issue of costs. For further information, please visit the Singapore Court's website for background materials on the rules of court, as well as digests on key aspects of the rules of court.